All right, it is noon now, so we've got 13 people here listening in, and we've got Tom Fredericks and myself, Florencia Kalila. We will get started. Welcome to today's webinar, Prepare Farm Transitions, Slowing Down and Planting a Seed for New Generations. Your speakers today will be Tom Fredericks and Florencia Kalila. I am Florencia, and I am a farm business management educator with Michigan State University. My pronouns are she, her, hers, and I am multiracial. And Tom, would you like to introduce yourself?
Yes, I'm an attorney, and my specialty has been keeping the family farm in the family. I've done that for about 35 years.
Thank you, Tom. We'll have some time for hearing a bit more about Tom's experience and interests in a minute. But before we move ahead, I would like to acknowledge that MSU occupies the ancestral, traditional, and contemporary lands of the Anishinaabe, Three Fires Confederacy of Ojibwe, Ordabwa, and Potawatomi peoples that was seated in the 1819 Treaty of Saginaw. Without further ado, let's get started. This is a little summary of the things that we will go through today very quickly. I've sent in an email handout from Tom Fredericks that has more detail on all of these things. So if you got that email, please take a look at that. And our next slide are the qualifications of Tom. So Tom, would you like to tell us a little more about that?
Oh, sure, Florencia, thank you very much. First of all, I'm a farmer, and currently I grow a lot of soybeans and tomatoes, but heart and soul is green and white. I've been a Spartan. I played Michigan State University football, and I was also in the Spartan marching band. Florencia and I are both Spartans, and we're proud to be here. Your turn, Florencia.
Thank you, Tom. So some of you know me, and thank you to those that know me and that are here listening in. But like I said, I am a farm business management educator with Michigan State University Extension. I was born and raised in Argentina to an Italian family of farmers, butchers, accountants, and small business owners. We used to have a farm and we lost it. So this topic is very dear to me. So I hold a bachelor's degree in agronomy from an Argentinian university, and then I got my master's in agricultural food and resource economics from MSU. I've worked with universities, government organizations, and private companies, doing project management, teaching, and facilitating. So here I've given you my news board link. If you want to read my newsletter, the projects that I've got going on, you can go there. And you can also schedule a one-on-one meeting with me if you want to ask specific questions to me or somebody else in the MSU Extension team. And the instructions on how to schedule that meeting are in this news board that I've got the link for in the slide. So let's keep going. So this is my first question to you, Tom, today, and welcome before we go on to the rest of you that are still joining in. We've got 17 people in the webinar now. So Tom, can you please tell me what is a will and why may I want one? Well,
the question is very well spoken here. 70% of Americans do not have a will. And for those people, the state has one written for you. So it may not be exactly the way you want things to work on your behalf. And I'll give you just one example. If you're a married couple, and one of you passes away, the surviving party gets 100% of the deceased's property. And that may not be exactly what the deceased had in mind. So it's important for us to each have a will. Secondly, if you don't have a will, it is even difficult to have a personal representative appointed. You could have a hearing in front of a probate judge just to decide who becomes your personal representative. Well, we used to call those people executors. Now they're called personal representatives here in Michigan. Back to you, Florencia.
Okay. I am asking question number 2 then now. You talked about probate. Could you explain a little more about what the probate process is like and how is it different if you do not have a will versus when you do?
I think there's a common misunderstanding about probate because you hear people say, hey, we can avoid probate, just buy this trust, you know, pay me $10,000, get a trust. No.
We just lost Tom. So I'm going to try to get in touch with him, try to have him call back in. In the meantime, there is the question and answer box down below. Please post any questions or comments you may have there. Also, if you are happening to hear Tom and I don't, let me know. I think he got disconnected though. Hi, Tom.
Yes, are you still there?
I am here, but you, can you call back to the Zoom number? We're waiting for you.
Yes, I will.
Okay.
Sorry, I don't know what happened. Okay, bye.
Bye. Okay, just let's give him one moment to join back in. I guess in the meantime, I wanted to make a plug for the Telfarm system that some of you are familiar with. So I'm going to go into this slide while we wait for him. So the Telfarm program, there's a link there if you want to check it out. It's a $550 annual fee, and it provides support and training for a couple of different record-keeping softwares, QuickBooks and PCMARS. So they not only support you in learning to use those softwares, but they also back up your records outside of your home computer in case it crashes. And they review your records to make sure that you are not making any mistakes in your record keeping. Okay, I think we've got Tom back, but I'm gonna just finish with this. Tom, if you can hear me. Okay.
I'm back, I hope.
Thank you. I was just talking about the Telfarm program, so let me just finish with this and we'll go back to where we left off.
Sure.
So anyway, other things that you get if you become a Telfarm program subscriber is a year-end tax planning meeting with an MSU Extension Farm Business Management educator like myself. There's 5 of us, I think, throughout the state. I cover West Central Michigan. And so that's one thing that allows you in the last month of the year to make any adjustments you need to make the most out of your taxes that you pay. You also get asset depreciation reports that you need to file your taxes or to give your tax preparer. And I think the most important thing of all of these things is the fact that they review and back up your work. But apart from this, there's a lot of education, tax benefits. Yeah, so you really get support for your record keeping. And as we're going to see with Tom in a minute, you really need to know what's going on with your farm before you start transferring it to another generation or a buyer. So I'm gonna go back here and try to find where we were.
I think we were talking about probate, weren't we, Florencia?
Yes. So,
and everybody goes through probate, and the reason why you go through probate is to get closure to the estate. If we don't file for probate and we don't go through that process, the heirs are forever exposed to claims against the estate. And we need to go through probate just to close it. Now, if you have a will, that is a very simple process. You know, it's usually unsupervised. It only takes maybe 6 months, and it's well advised for all of us to go through probate. I'm on slide 11, which says probate, and I'm prompted here to talk about the fact that, you know, we publish actually a newspaper ad somewhere saying the deceased has passed away. Did he or she owe anybody money out there? Well, within about 3 months, those claims are avoided just by filing for probate, doing an inventory of what's there. And let's say we discover that there are some credit card debts out there. You know, my rule of thumb as an attorney when I try to settle an estate and those kind of claims is to negotiate 10 cents on a dollar. So if the decedent owed $10,000, you know, my rule of thumb says, hey, let's offer him $1,000. And usually you get that. Okay, back to you, Florencia.
Okay, Tom. So you kind of touched on what my question 3 was. That was our next question. You talked about creditors. You talked about credit card bills. Let's talk a little more about utility bills or larger loans, machinery loans, land, mortgages, that type of thing.
Well, first of all, you know, every farmer's most precious property is the farmland, the farmhouse, and the barns and other structures. I try to put as many interested family members on a deed as is possible, and the survivor takes the land, all of that, via a deed. Secondly, there are a number of properties that have titles: automobiles, trucks, boats, mobile homes, you name it. And you can do the same thing with those titles. You put somebody else on that title, and all you need is a death certificate for the survivor to take possession of that particular thing. So deeds and titles are a legitimate way to avoid probate. Not that you as an individual avoid probate, but you know, that particular piece of property or land can avoid probate via deeds and titles. Next question.
Thank you, Tom, and thank you for answering my next question without me having to ask. So we our next topic that we have here on the next slide is banking and cash on hand. And so could you tell us a little bit about what can we do for to avoid them or minimize the expenses that they may have to pay after you die?
Yeah. Well, you know, Florencia, I'm going to put in a plug for your Telefarm product because I have walked into so many situations where we didn't know what the bills were, you know, who was owed anything. I remember this one instance where a fellow who sharpens chainsaws came up the driveway with an invoice. And I had to decide who to pay and how often to pay and what priority. Telefarm is going to help anybody like me or a personal representative decide how to pay that. I also recommend that you have somebody on a bank account because right after the death in a family, boy, there's a lot of bills to pay. And banks get really funny about somebody's absence, and they lock up those bank accounts. So to have a son or daughter on your checking account makes a lot of sense to me. I also like cremation policies. I personally have one. I paid $2,500. It is with the Neptune Society, and if anybody's interested, just send me an email, and I'll give you the phone number of Joanne Brady, who's just wonderful. She works for the Neptune Society. Okay?
Okay. Thank you, Tom. So let me back up a little bit. There was another question I wanted to ask you. How is a will and joint ownership not redundant? I mean, in which cases is it a good option to have a will plus joint ownership of certain assets? And I think you...
Well, yeah, I think a will is a blanket coverage of all your goods, many of which are too numerous to mention. And we have distributions of things that are not mentioned specifically in joint ownership. And in the will, for example, you can also have preferences for your funeral services, charitable deductions, and donations, all kinds of things like that. So you need both a will and I like joint ownership for bigger assets. Okay?
Okay, thank you. Another question I wanted to ask you was about trusts. Will they help with decision making after I pass away?
Yeah. In a nutshell, yes. I do not think most people are as wealthy as Bill Gates, and most people don't need a trust. If you do, I can help you get one. But trusts are about $10,000 in that vicinity. And with many farmers, I've looked the surviving spouse in the eye and said, you didn't need a trust to get the farm. So anyway, let's just say most trusts are probably superficial.
Thank you. Okay, so give me a few more reasons I may need my will.
Well,
or examples.
I like having a will, number one, to point out who the personal representative is. If we don't have a designated personal rep and other options after that person might not be available, it can take weeks, thousands of dollars in attorney's fees, and perhaps even a hearing before a probate judge just to establish who might be that individual. So that's a good reason all by itself for having a will. But if you have minor children, you get to pick in your will who would raise your children if you're not available to do so. And I do like to see alternatives if that designated individual is not available. So raising your minor children's a big issue, and I think that's a second reason to have a will. I could go on and on, but time is short.
Okay. Before I move on to our next question, I see that there is a question posted and there is somebody raising their hand. Thank you for those. Please keep those questions in your head. We are going to address them once we're done going through the slides. So let's very quickly ask.
Very good.
So Tom, here's my next question for you. So how do I go about writing my will?
I want you to create a list of everything you own. And the Michigan State Bar, in its wisdom, allows us to attach a list to your will. But you have to make that list. You can say what happens to every one of your properties, even, your china, your silverware, your televisions, who gets those items. You make a list, you check it twice. See Me allows us to attach a list to the will that's very specific about certain items. And, let's say you're very spiritual or religious. You could even pick out the music that would be selected for your memorial service. Those kind of things can really divide a family unless you pick and choose where things go and what gets done. You can choose the difference between a burial, for example, or cremation, as I have chosen. And of course, we have an explanation about the list on slide 26.
Yes. I do have one more question about the list, though, and it is, so can I then refer my will to this list, which is not annexed to the will at the time of signature? You had told me that I could sign the will and I could have this list and then I could update the list as needed. My question is, what if I signed my will
Yes.
Before I made changes to the list?
Your list would still be valid. Okay.
Okay. Thank you. Yeah, that's what I wanted to know.
Yes, ma'am.
So next question.
I think we're at slide 30. Yeah. Yes, ma'am.
Yes, we're going to talk about patient advocates now. And my question to you about patient advocates is, I've heard about them and their importance in life support decisions, but could you tell me a little more? Who decides if I do not have a patient advocate appointed?
A judge. You would have to have a hearing before a judge, and that is a very divisive, potentially emotional and difficult legal proceeding before a judge.
Thank you. Anything else you want to say about patient advocates before we move on to the next question?
Well, yes, you can. Those are generically available at any hospital, but I have an official version of a patient advocate that is more expansive and more inclusive. I recommend you do that at the same time that you get your will done. You need a patient advocate, durable power of attorney, which is mentioned on slide 32, and of course your list. So those 4 items are what I always recommend for my clients.
Thank you. And yes, we will talk about the power of attorney next. So about power of attorneys, what if I am not on life support, but I am still not able to make decisions? What is a power of attorney, which is what I believe would apply in this situation? Who decides if I do not have a power of attorney? Does this matter for bill payments? So tell me what you know about power of attorneys.
Yes. The durable power of attorney, first of all, allows somebody to write checks on your behalf if you're unable to do so. And it's an automatic, in effect, document which you can use to go to the bank and write checks. But again, I strongly recommend you have somebody close to you on your checking account who can write checks automatically, even without a power of attorney.
Thank you.
Okay?
Yes. So I have one more question, and that's about business entities. So do you have any advice on that arena?
Well, you'll see slide 35. I recommend limited liability companies for farmers, LLCs. You'll notice you file for an LLC with the state of Michigan, only costs you $50. And there's nothing I've been able to discover that an LLC cannot do that a trust will do for, like I said, $10,000, plus you have to have a separate income tax return just for the trust. I like LLCs for farmers, and they're easy to get. And what you do, folks, is you create an operating agreement that replaces so many of these documents we've been talking about within the LLC. Next question.
Okay, I have probably one more question, and we are getting quite a few questions from people. So thank you to all of you that are typing in questions. And so as we are approaching the end of my time with you, and I'm preparing to open it up for the rest of attendees, I wanted to ask you about taxes. What are the estate and gift tax exception amounts as of this year? And what other taxes may my heirs be faced with after I die?
Well, let's take a look at slide 37, which is a kind of a summary of what's going on here in Michigan. There is no inheritance tax in Michigan for the vast majority of people. Other states do have inheritance tax. The estate and gift tax exemption for 2021 is 11.7 million and 23.4 million for married people. Property taxes are an area of my specialty. Farmers can appeal their property taxes up until July 31st of 2021. And to do an appropriate property tax appeal and to even figure out how much property you own and how much is it worth and how do I split it up, I like slide 39, which is all about appraisals. Mm-hmm. For a property tax appeal, you've got to have appraisals to have any success, okay? Next question or concern, Florencia, before we get to Bernie Harwell.
Yes, so thank you for touching on appraisals. I wanted to ask you about that. And so I'm just going to move to my last question. What's your takeaway for today?
Oh, I want you to take a look at slide 42. Many of our farmers remember Ernie Harwell, the beloved voice of the Detroit Tigers for many years. He had 4 kids, and he made them all personal representatives in joint control of his estate. This is a gentleman who was worth $5 million in just baseball collection, and he worked for Blue Cross Blue Shield well into his 90s. You know, his gifted voice many of us will remember his radio broadcast. Unfortunately, his estate became bankrupt, even though it was worth well over $10 million, because the kids couldn't agree to everything. So I recommend picking one person as a personal representative, and that leads us to slide 43, which would be my will's tips. And, you know, I'm happy to address any of those concerns.
Okay, I think we can leave this slide up while we start answering questions. It's 12:30, and all we had after this was Tom's contact information, which I'm gonna leave up for a minute. Okay. The first question we got, and then I'm gonna go to Steve, who has his hand raised, says, I have a question about aboriginal title. There is a dispute on a piece of property I have interest in. It is alleged, but is really a fact, that land was taken by adverse possession through force and intimidation. There are indigenous people demanding the land back, but now it is a land grant college. Will we have to give the land up if the doctrine of discovery is overturned?
Well, to answer your question, generally speaking, adverse possession requires a 10-year period of time to elapse, you know, where the original owner had to be aware, you know, that somebody else owned that property. And it has to be, well, you know, that's an interesting question, but it has to be more than just cutting the grass. It has to be, the adverse possession has to be a permanent structure, a fence, something that, you know, anybody could see, you know, for 10 years. Okay, does that help answer the question?
I'm not sure.
I don't think I know enough. Yeah. I don't think I know enough facts to really give him a specific answer, just a generic one. And I would be foolish to try to answer that question right off the top of my head.
Okay, to the person that asked that question, if you would like to send me an email, I can try to get you an answer, try to get you in touch with somebody that may know. If you want to speak out loud, I could also do that during these next few minutes.
Florencia, let me talk about a couple of my will's tips. How many copies should there be? I recommend just one. In fact, I don't even want a copy of the signed will. I want you to have one copy. Keep it in a folder where your personal representative is instructed to find it. And I recommend not keeping it in a bank safe deposit box, because as soon as a party dies, that box gets closed up, locked up, until a probate judge orders it open. Well, we need that. We need that will, the day after somebody dies, for sure. And so what was your next question, Florencia?
Well, our next person waiting to ask a question is Steve. So Steve, I am allowing you to talk now. You can unmute yourself and we should be able to hear you. Steve Klemper.
Hello, Steve. Oh, by the way, while Steve is getting online, I'm going to also recommend, according to state law, you have to have two witnesses sign your will. And I recommend getting it notarized too. I did a will for a good friend of mine named Roy. He was in this office on December 5th. I called the bank for him, and I instructed Roy to go to the bank, find a couple tellers who would witness his will. Of course, they did the notary for free. 1 week later, I got a call from his widow telling me that Roy had died. And luckily, you know, we went to the bank, got his will signed by 2 witnesses, and had it properly notarized. And she couldn't have been more thankful that we had done that. Steve, are you on yet?
No, I think he may have raised his hand by mistake. So we're going to move on to the next question. But I actually had a question about the witnesses and the notary for the will. Is it true that you really can sign your will at home with your, you know, family members, friends, whoever as your witnesses, and that you don't actually have to have it notarized for it to be valid?
Well, that's true. Actually, a will can be effective without witnesses if the will is written in your own handwriting, signed and dated at the end. It's called a holographic will, and it's plenty valid. However, if you type up the will, it needs to have 2 witnesses for sure. I try to recommend not having a beneficiary witness a will. I think that can be a problem. But I certainly recommend 2 witnesses and a notary in every case. I think that it just makes sense.
Thank you. Okay.
Yes, ma'am.
So I have Amy next. Amy asked, I believe the power of attorney is only good while the person is alive, and once they pass, they can no longer write checks, etc., is what she said. And I think we agree with her. Do you want to make any comments on what she said?
Well, you know, after somebody passes away, it's the will and the list that govern what's happened. And after somebody passes a will, the representative is the personal representative. And that could be somebody different, you know, than was on the durable power of attorney. So, yeah, I think she's absolutely correct about that.
If you do the other thing, which would be having a joint bank account, then they would still be able to write checks, whether you are alive, able to decide or not.
Yeah, and you know, again, man, after somebody dies, and I've been in this position, you need a lot of money and quickly, probably sooner than life insurance can arrive. So having somebody on your checking account is important to be able to pay for even a memorial luncheon, you know, after somebody dies. You know, I mean, a caterer might want to be paid thousands of dollars, you know, I mean, think about it. You're actually incurring the same amount of costs as somebody's wedding reception. So you need access. The personal representative needs access to money in a hurry, you know, after somebody dies.
Okay, thank you, Tom.
Yes,
There is one more question, and while we address this question, I'm going to move this slide to your contact information so that people can see your name, address, email address, and all of that. So our next question says, how should someone properly sign a check pursuant, I'm not sure I know how to pronounce that, to a power of attorney? How should somebody properly sign a check pursuant to a power of attorney?
Well, they just sign their own name. You know, you can't sign somebody else's name without having some legal problems. If the power of attorney specifies that your name can be on that check, you should sign it that way. And what else can we talk about here? Oh, you know what? I'm going to mention something that really isn't on any of our slides, but you're going to need at least 3 true copies of a death certificate. And you make copies of one of those. The true copies have, you know, kind of a raised stamp of approval by the county clerk. But most credit card companies and debt collectors don't need true copies. Somebody will try to sell you 10 of them. They are kind of expensive. I'm going to recommend that your personal representative starts out with 3 of those and then just make 10 Xerox copies to be used to settle credit accounts and pay bills. So you're going to need death certificates, okay?
Mm-hmm. Thank you.
That's a bonus tip.
Thank you. We appreciate it. We have one more question from Amy. It says, I would recommend, so it's a comment, not a question. And it says, I would recommend not using an adult child to be the executor of the estate if possible. Use someone outside, even if you have to pay them, as it's a lot of work to close an estate and can cause issues between siblings.
Well, that's up to the it's up to the writer of the will to make that call. I agree that being a personal representative is a lot of work. My wills usually allow somebody to be compensated, whether they're a son or a non-relative, whoever it is. Now, you wouldn't have to pay them attorney wages or CPA wages or any of that, but they should be able to charge the estate for their time and expenses. And I'll give you an example. If somebody has to drive to Sanilac County, you know, to file probate forms, you know, that's for me about a 3 or 4 hour drive, plus a lot of gasoline. You know, I think a personal representative should be able to charge the estate a reasonable fee for those things. Therefore, it really doesn't matter if it's a son, daughter, or friend of the family. I think they all should be paid something for their expenses and their time. Is that clear enough, Amy?
Well, she's not able to speak unless we allow her to. So Amy, if you would like to, oh, she said yes. Okay.
She can always send me an email if she needs a more specific response.
Yes. Okay, so those were all our questions we got so far. We had like 20 people in attendance and it's 12:43. So I'm going to say if either one of our attendees has another question you would like to ask, this would be the moment to do that. In the meantime, Tom, if you have any other quick tips or comments you would like to make before we close, this would be the time.
Well, this is my final word of advice. Don't be like Roy. If he had died on December 4th with no will, and I was bugging him for about a year to get his will done. Good friend of mine. Don't put it off. People find writing a will to be an uncomfortable project. Make it a priority. Maybe, well, here it is, January 28th. Let's make this a New Year's resolution that we all have them. And, you know, like for my son, I have a folder. I walk him over to where my file cabinet is, and I say, Gordy, if something happens to me, get this folder out. Everything in here will take care of our property. And by the way, here's my cremation policy. and I've got all of the checks, you know, there that show I'm paid in full. You know, let's make getting this a priority, and don't be like some folks who unfortunately pass away too soon before they can get to a project like this. That's my final word of advice to all of us farmers, and you know, God bless you.
Thank you, Tom. We have somebody said, thank you. As a result, I will be writing my will soon. And speaking about as a result, you're going to be receiving a follow-up email with a link to a survey. It may be that when you close this webinar, the survey will just pop up on your computer. And either way, I ask that you please fill in that survey with your comments and suggestions as to how you felt about this conversation and how we could make future programs better. Okay, so we are now at 12:46, and this is all I have for you all today. It seems like Tom has also made his final comments, and you all have had an opportunity to do that as well. So thank you very much for joining. I look forward to seeing you at the next webinar. Stay in touch, email us if you need anything, and we thank you very much for coming.
And go green.
Yay, go white.
Good answer, Florencia. Take care.
Of course, you too.
Bye now.
Bye.